matter of Cheshire Cavity Storage Ltd and another, and the Commissioners of Her Majesty's Revenue and Customs.
Yes, Mr. Peacock. I can tell you that we have read the FTT's decision, the Upper Tribunal's decision, and the skeleton arguments, and quite a lot of what was on the reading list.
Well, I'm grateful. I appear in this matter with my other friend, Ms. Black, for the appellants, the companies in the EDF Group. My other friend, Ms. Narton, appears for the respondent commissioners.
Yes.
I'm grateful for your Lordship's observation as to what the court has had a chance to read. One other matter of housekeeping, I think the court knows that there is a transcript being taken,
yes,
but it's being taken off the live feed.
Indeed. I gather that the transcribers are listening in on Skype or similar.
Yes. He or she is either isolating or at least suffering from COVID.
Oh, right. And will we be supplied with a copy of the transcript? It's an overnight transcript, I take it.
It is one of them, and that can be arranged, yes.
Yeah, thank you. So we know what the case is about.
Do you know what the case is about?
I think we would like to hear argument on what's been called the common law meaning of plant from both sides before going on, if need be, to decide the other points, which the FTT decided, but the Upper Tribunal did not.
Well, yes. So, some preliminary observations by way of introduction. You will have seen that there is both the common law question and the statutory question. By way of background to both of those, the court has perhaps picked up that there is no deduction in computing profits for corporation tax purposes for capital expenditure. You are only entitled to make a deduction for revenue expenditure.
Yeah.
Given that special allowances have long been made since the late 19th century and in their modern form since 1945 for certain types of capital expenditure, the purpose being to encourage investment in capital assets. As the law now stands, you need capital expenditure incurred for the purposes of a trade, where that expenditure is on plant and machinery, the common law question, and is not barred by, or if barred, is then saved by, the statutory provisions that are now found in sections 21 through to 23 of the Capital Allowance Act. The appellants here are companies in the EDF Group, major UK energy business, and we're here concerned with the gas storage facilities, or cavities, being part of the EDF Group's gas infrastructure business. The court will now be alive to the fact that the cavities are either the result of the extraction of salt or were specially created in salt rock, such that in either case, the relevant EDF companies have been left with these teardrop-shaped underground cavities which hold the gas, and then through the facilities and equipment at the surface, take gas off the national gas transmission system.
They're quite large cavities.
They are.
Right?
Well, Lord, yes, they are.
But we're only concerned, I thought, with those cavities which have been created by leaching and debrining. I think the background facts tell us that there has been salt mining, and indeed Cheshire is famous for its salt mines. So I take it that some cavities are, if you like, worked out salt mines.
Some of them are, my lord, so the detail doesn't matter, but some of the expenditure here was for both leaching and debrining, and some of it was only concerned with debrining.
Including the worked out mines, salt
Yes.
mines. Oh, I see.
So when these companies took the leases of the relevant sites, some of the cavities were the product of salt mining.
Right,
So they only needed debrining.
right.
Some of them needed creating by leaching, and then they were debrined.
Thank you.
Now, your court will also have picked up on this, but some of the gas is always left in the cavities once they are in use, so as to prevent the collapse of the cavities due to the pressure of the overburdened rock, and that's referred to as the cushion gas, as opposed to the working gas. The cushion gas is itself plant by statute. The court will also have anticipated that whilst one can see photographs and plans of the the kit and the apparatus at the surface, that which is accepted to be plant. Obviously one can't see photographs of the cavities underground, they're not accessible. There is nothing in them apart from the gas and residual brine or marl right at the bottom of the cavities. So they are
it probably doesn't matter, but just for my curiosity, insofar as these cavities were used for salt mining, they would have been accessible somehow, would they, or not?
The way that you mine for salt is in effect the same process.
Oh, I see.
You drill down, pump water in,
Get
and
the
take
brine
brine out,
Right.
and then the brine becomes the salt,
Yeah.
which is what makes these suitable, as it turns out now, for gas storage. Because again, the court will have picked up on this, but once one has removed the brine, that process of leaching and debrining creates an impermeable barrier so that the rock, the halite,
Yeah.
is then suitable to hold the gas as if in a container. So what then we are left with is these underground, I'm trying to use a neutral term that was used below, a cavity. Because they are underground, the pressure is necessarily greater than at the surface, and that greater pressure allows the storage of more gas than would be possible at the surface. It's also perceived to be a safer place to store gas, but certainly one can store greater volumes of gas. And that pressure differential between the surface and the storage beneath the ground allows there to be what is called free flow, i.e. without using a compressor, either into the cavities or out of the cavities, depending on the relative pressure differential between the National Transmission System, the NTS, and the cavities themselves. So given those elements, and given the processing and other kit that is at the surface, which obviously is designed to make these cavities work so as to either add gas to or take gas from the NTS, the common law question is whether the cavities are plant or machinery. Now, for our part,
just to be clear, we're only looking at the cavities.
we are, because
Nobody is suggesting that the whole ensemble should be viewed as a single item of the plant.
one can't ignore that, but what the commissioners accepted long before this litigation started was that the kit or the apparatus that is at the surface for processing and moving gas in or out did qualify as common law plant.
Yeah.
So that's been accepted.
No, I understand that, but I understood from the FTT decision, I think it's paragraph 94, that nobody is asking for what the Judge Mosedale called an entirities approach.
No, there is no entirety debate in this appeal. But I do want to come back to the significance of that when we come to look at the authorities. Now, if these companies were storing gas at the surface, let's imagine in steel tanks, one might think of a mental image of the LNG tanks at a harbour that might be used to store gas that's imported, there would be no question that they would be regarded as plant. So does it matter that the gas here is stored beneath the surface in cavities that have been formed out of the halite, the rock, by that process of leaching? We say no as a matter of principle. The location, above ground or beneath ground, doesn't matter. Size doesn't matter, big, medium or small. And the method of manufacture or creation doesn't matter. What matters is the function. And here, those cavities, we say, and their function is as underground pressure vessel containers to hold the gas pending its reintroduction back into the NTS. Now, as the court will appreciate, that's a significant debate for these EDF companies and others in the gas storage industry in the UK. It's also important in a wider sense to the UK's energy security, clearly a topical issue just this week. But we see these cavities, as indeed was recognised by the first tier, as a part of the UK's gas infrastructure. The first tier recognised that they represent about 7% of the UK's storage capacity.
7.
7. And they represent about 20% of the UK's daily delivery capacity. And the court will also, perhaps have seen below, there's a reference to fast cycle. And that's a term used in the industry for the ability to either fill or empty a particular container on a fast basis so as to take advantage of either price differentials or to meet shortfall in the system.
Does the technology only work with salt? Are there other underground storage facilities formed in a similar way? Come back
to the best of my knowledge, I only know of them working with halite, because halite forms that impermeable barrier that will hold the gas, so one doesn't need to line them. So theoretically, having created this teardrop shape, you might have dropped a pipe down to spray some kind of polymer all over the inside to form a lining, and then you would have had a polymer-lined something holding the gas, and that would have no doubt cost money. But here you don't need to do that because the rock itself, and I can't say to the court that it's only halite that has those properties. I only know of it being stored in halite.
But anyway, these particular cavities are formed out of the natural rock.
They are. So this common law question of some significance both to EDF and the gas industry as a whole, the wider principle of how you go about determining what is plant, where you have an item, I'll put this as neutrally as possible, that may well have an apparatus function and may well have a setting or a premises function. So how do you answer that debate of principle matters enormously for anybody who may incur capital expenditure on larger structures. So it's of real significance to the future development of large infrastructure in the UK. And I'll come back to that if and when we get to the statutory questions, because there are also important aspects of what is meant by the reference in List B to an undertaking in the gas industry. That's all of some significance. But enough by way of introduction. If I then turn to my ground one, common law of plant, court will be alive to this, but it's a question that's troubled the courts on many occasions over the last 130 years. Some of the cases, though not all of them, are in the bundle. The relevant principles for our part are well settled, or at least were until we got to this particular appeal. And I propose to tackle this as efficiently as I can by firstly identifying what we say are the relevant principles, looking at the authorities. Secondly, identifying where we say the first tier went wrong. And then thirdly, identifying how the upper tribunal correctly saw that the first tier had applied a test that the upper tribunal thought was wrong. But then the upper tribunal in turn introduced what we say is still the wrong test. The court will perhaps have picked up that the upper tribunal do recognise that the test that the first tier applied was one that the upper tribunal thought was not right. Now, it says there is
predominantly. So the predominantly idea.
Yes, the first tier said the test is predominance.
Yeah.
Leaving aside the statutory exclusions savings, if we are with you on these points, do we remit it or do we remake the decision? Because we do have the power to remake the decision if we are satisfied that the upper tribunal was wrong.
Yes, you do have that power under Section 13 of the
Yeah.
Act. In these circumstances, you would not need to remit it
Right.
because the first tier has made relevant findings of fact that would allow you to apply what I say is the right test.
Right.
But the first tier said the test is of predominance or of significance. It's put two slightly different ways. And the upper tribunal said, well, that's not quite borne out by the authorities. But the upper tribunal said, well, the test is it more appropriate to regard it as X or Y? And then the upper tribunal say, well, in substance, those two are the same. And I object to that as well. They're not the same, they are different tests. So relevant principles, we do, I'm afraid, have to start with Yarmouth and France, the horse.
Yeah.
Possibly the most famous horse, at least to tax lawyers in the case law. It's in Volume 1, Tab 5. It is a short passage, but it becomes seen as the fountainhead of all of this. So it's not a tax case. It's an employer's liability case about a horse that kicked a workman.
The vicious horse.
It was a vicious horse, and the question under the Employers' Liability Act was the horse plant? Except the carts were plant, but was the horse plant? And the answer turns out to be yes. But it's page 78 of the authorities bundle, page 658 of the report,
Yeah.
Lord Justice Lindley, just between the two hole punches, no definition of plant in the Act. Now, that Act is the Employers' Liability Act. It includes whatever apparatus is used by a businessman for carrying on his business. So there has to be a business use requirement, but that's not enough. So not his stock in trade, so not the stock that you turn over, but all goods and chattels, fixed or movable, live or dead, so live that extended to the horse, which he keeps for permanent employment in his business. So there has to be a business use, not stock, permanent use in the business, and that is later understood, we say rightly, as drawing a distinction between items with which the business is carried on, which I'll refer to as apparatus or an apparatus type function, although sometimes the phrase used in the authorities is a plant-like function. So items with which the business is carried on, in contradistinction to items in which the business is carried on, because they are said to be either the premises, one thinks of a factory, or it might, in some instances, be the setting in which the business is carried on. And when we come in a moment to a dry dock, the dry dock's not a factory, it's not premises, but it might have been said to be an asset in which the business is carried on, and therefore not qualified.
But at any rate, it's gone beyond goods and chattels.
It has. Now, just before we turn on to the next authority, I think the court has this in mind, but there are instances where the case law is concerned not with a building, but with a large structure, typically made out of concrete, it doesn't have to be, a large structure that may itself have a function as apparatus, as an item with which the business is carried on. And of course, it may also have a function as an item in which the business is carried on. So the headline question of principle is, if you have an asset that has both of those functions, should it be classified as plant or not? Now, my headline answer to that is that the authorities had long recognised if an item had both an apparatus function and a setting or premises function, it had both, then it would be classified as plant.
Then it
Would
be plant.
be plant.
Is that as a matter of dogma? So that once you say you've got both, then you default into plant? Or is that just on the facts of each case that you go through and you approach it looking at what the relative functions are?
It might have been said back in the mists of time that it was the product of the facts of a given case. But it has hardened, if you like, into principle, long recognised that what was excluded from the common law notion of plant were items that merely or only had a setting or premises function. And indeed, once one understands Berkeley-Curl, one can see that that was the conclusion of the majority. The majority do not decide Berkeley-Curl on the basis that somehow one function was greater or more significant than the other, nor do they decide Berkeley-Curl on the basis that it was more appropriate to see the asset as X or Y.
So if it's both functions, then you get home,
Yes.
irrespective of whether it could be seen as more one or the other.
Yes. That's what the authorities say.
So in any sense in which it can be described as an item with which the business is carried on, that's enough.
Yes. And I'm going to show you they are almost all authorities in this court or in the House of Lords. And that is a constant, mantra's too strong a term, but it's a constant recitation of that as the dividing line if we look at the chronological progression of the authorities. Yeah. Now, last point, just to clear the decks before we move on in the chronology. Obviously, we're not here concerned with premises. These cavities are not a building in any sense. They provide no shelter to man nor beast. They just hold the gas. Can't get inside them. So when we come to think of this debate, on the one hand, there is a setting function, and on the other hand, there is an apparatus function. So turning on chronologically, I'm not going to take you to all the authorities because we can pick up in later ones passages from the earlier ones. So if I don't take you to authority, I'm not shying away from it. It's just in the interest of
I
time.
think if you took us to all the authorities, we'd be here for 2 weeks.
Well, my lord, yes, and the court doesn't want that, and neither do I. But just so you know what's in them, I'm just going to tell you what the case, as we pass, I'll tell you what the case is about. So just behind tab 6, old case from 1905, John Hall Jr., was about an old hulk of a ship that was used to store coal. The hulk was taken, the ship was no longer movable, it just held coal, held to be flown.
But as was commented in later cases, the point was conceded, it wasn't argued, there's no explanation.
My lord is ahead of me. It's accepted to be plant. The judge says, of course it's plant, but he doesn't explain why. Yeah. Margaret, behind tab 7, is a case about the water tower at Lowestoft that held the water at a certain level to provide pressure for the flow of the water.
Probably wrong.
Well, House of Lords say 3-2. It's wrong. But they say that 3-2. But the judge in that case thought that you don't look at function, you just look at what it is. And he thought, well, it's just a concrete tower. 3-2 in the House of Lords, they say that's wrong. We can skip union cold storage, that's about cold stores. So if we turn on to tab 11, again, in case I'll come back, or we'll pick up later on, but this was the Gerald case about movable office partitioning. So they were, in modern terms, in effect, open plan offices subdivided by partitions that could be and were moved. The debate was the movable partitioning to be seen as if it were a wall, or was it movable partitioning that made it look more like plant? Held to be plant. And then turning on tab 13.
I mean, the problem with a case like Gerald, let me suggest to you, is that if, as Lord Justice Pearson says, either view could have been taken, then it's not a decision of this court that the partitions were plant. It's merely a decision that the, I can't remember whether it was general or special commissioners, general I think, weren't wrong to say
Correct.
it was.
And I accept that. So they weren't wrong in their conclusion, but of course, had they misdirected themselves as to the meaning of plants,
Yeah, then they would have been.
then they would have been wrong.
Yeah.
So I accept.
So I think we've got to be a bit careful with some of these cases where the decision of the commissioners, whether general or special, is upheld. Court's not really, well, in many cases, not saying more than they were entitled to take that view. It doesn't follow that they would have been wrong to take a different view.
Well, that is a fair observation, if I may say so, in relation to some of the authorities.
Yes.
Some of them tackle the principled question as to what is, as a matter of law, meant by plant. Yeah. But I accept that as regards Gerald. Behind tab 13, there is High Court of Australia case called Broken Hill. It's a long case about mining operations, typically in Western Australia, where Mr. Justice Kitto had something helpful to say about the matter of principle, drawing on the English authorities. Mm-hmm. But we will see what he said about that when we get to the Schofield case. And just as a matter of housekeeping, there was an internet report that wasn't the Australian Law Journal report, and I think you've been provided now with both.
Oh, yes, yes, yes.
But they are the same. One is in proper report form.
Yes.
So that takes me to tab 14 and Berkeley Curl. So, the court, I suspect, is alive to the facts. It's a dry dock that was built on the banks of the Clyde. In simple terms, a very large hole was excavated on the banks of the Clyde. The base of it was covered in poured concrete. 3 of the sides were concreted, and then the 4th side out onto the river was what's called a falling leaf gate. It's an enormous steel, I suspect, but a gate that would fall into the river at high tide to allow the ship in or out, and then you brought the gate back up again to form the 4th wall of the dry dock. And there was a lot of electrical and mechanical kit on the side of the dock for bringing ships in, providing power, providing drainage, matters of that sort. That was all accepted to be plant. The items in dispute, one can see at the foot of page 244.
It was the concreting and the excavation.
My lord, yes. So 244 is that which was allowed, the 308,000 less the grant. And the top of 245 of the bundle is that which was disputed, and it was the excavation and the concreting. And the special commissioners, foot of page 245, said the concreting qualified, but the excavation did not.
Yeah.
The Court of Session allowed both items, and so then the matter proceeded to the House of Lords. And you see that the Court of Session had allowed both on page 246 of the bundle between letters E and F, Lord Reed. The First Division held that the larger allowance was due for both. page 247, between letters F and G, he refers to a case about some knives, Herrington and Madden, and he mentions Yarmouth and France. And then at letter G, it was suggested to us that one test to apply was whether the ordinary man in the street would regard the company's number 3 dry dock as plant. We thought it was not open to us to apply such a test of first impression. So when one thinks a little further down the chronology of regarding it as more appropriate to see it as A or B, that's not a million miles away from the approach that his lordship rejects in Barclay Curl. But then turning on to page 248 of the report, of the bundle, letter G, his lordship addresses what is meant by plant, refers to Yarmouth and France and Gerald and John Good, and then at letter H, buildings or structures of machinery and plant are not mutually exclusive. That was recognised in Gerald's case. And then he says, undoubtedly this concrete dry dock is a structure, but is it also plant? The only reason why a structure should also be plant, which has been suggested or which has occurred to me, is that it fulfills the function of plant in the trader's operations. So he's saying it's a functional test, which is the ratio of the majority. And if that is so, no test has been suggested to distinguish one structure which fulfills such a function from another. So he's saying it's a matter of function, and once you have that apparatus-like function, there is no further test. Now, I accept he does not go on to say it's not a question of predominance or of greater significance. What he's saying there is, once you've found that it has a plant or apparatus function, there is no other test. Yeah.
What does he mean by the penultimate sentence on 248?
Well, I quite accept, he goes, I do not say that every structure which fulfills the function of the plant must be regarded as plant, but I think that one would have to find some good reason for excluding such a structure.
Doesn't that undermine your response to something one of us put to you earlier? That if it's in any sense apparatus with, not in, then it gets over the line. Doesn't that rather undermine that?
Well, what he says there is there would have to be some good reason, but in the sentence before, he's rejected the suggestion that there is some other test. And then, obviously, I suspect because it was a feature of that debate, he says in the last sentence, mere size is not sufficient.
Well, what he's saying is that function is necessary but not sufficient, isn't he?
Well, my lord, if one reads on, top of 249, here it's apparent there are two stages in the company's operations. Ship must be isolated from the water, and then the inspection and necessary repairs must be carried out. If one looks only at the second stage, it would not be difficult to say that the dry dock is merely the setting in which it takes place. So he regards that as a potential reason that might prevent its entitlement as plant.
But on the facts, he says, the whole dock, every part of this dry dock plays an essential part
in
getting
the whole
large
operation.
vessels into a position. That is the first stage.
Yes.
Where they can work on them, and the whole dock is the means.
So what he's saying is,
So that's an entirety's point.
well, it's not a physical entirety point. What he's rejecting there is the proposition that you can split the operations into two. So he said theoretically you could split the operations into two, but that's not a proper reflection of what this company's business is, nor what the dock is used for. He's saying you've got to look at it as a whole, the operations as a whole, and once you do that, you can see that there is a plant function, an apparatus function, and even though one element of that operation is to hold the ship in situ, which might be seen as a setting function, that doesn't matter for the reason that he gives at letter C. It is wrong to regard either the concrete or any other part of the dock as a mere setting or part of the premises in which this operation takes place. So he's saying you have to look at the operation as a whole. There is an element of that operation that you might think of as setting, but there is equally an element of that operation that is an apparatus function. And once you cannot say that it is merely setting, allowances are available.
The last sentence isn't, it says the whole dock is the means, doesn't it?
Well, and
The
that
word whole, the adjective whole qualifies the word dock, not the word operation.
that is true, but one needs to read it in light of the first sentence on that page where he's dividing the operations into two. So what he's saying in the last sentence of that paragraph is you can't say that part of the dock is used for A and part is used for B. The whole dock is used for both operations. You cannot physically separate the asset into A and B, and you can't conceptually separate the operations into 1 and 2. All of the dock is used for both parts of the operation. And once that is true, he says you've got an apparatus function for the whole dock, and you cannot say it is merely the setting, the whole dock, and that's why you get allowances.
Just to put the counter argument, because this is an important passage, isn't it? Is that are you elevating a finding on the facts? Because one reading of this would just be that Lord Reid was simply looking at what happens in the dock as a matter of fact. He says, yeah, there are elements of it that are one sort and elements of it that are the other sort. But overall, I take the view that this is a piece of plant because of the whole of the entirety of what it's doing, and you're elevating that into a principle of law.
Well, Lady, as one sees how one needs to understand what it was that divided the majority from the minority. I'm going to show you all 5 speeches. But secondly, we need to see how this has been understood and applied in this court in later authorities. So I take my lady's observation, but when we see what happens, that's not what is taken from Barclay Cole. So then he goes on in argument to deal with the dam, and he says, well, land in its natural state may well not be plant, but he's not going to decide.
With respect, he doesn't say it may well not be. He says clearly land is not plant.
But then he goes on.
Well, then he talks about a dam which is constructed.
Yes. Yes.
And thus far, Lord Reid is dealing with the concreting of the dock.
He is.
We'll come on to the excavation later.
I'm going to show you all of the passages. So then he deals. He addresses the dam. I don't shy away from any of that. Then he addresses Margaret, and he thinks Margaret is wrong. And then at letter G onwards, he deals with the cost of the excavation. And here he rightly notes that the language of the statute then and now extends to expenditure on the provision of plant. So he has to ask himself whether the excavation is expenditure on the provision of plant. And consistent with his first conclusion, that the dry dock is plant, then the excavation is necessarily incurred on the provision of the plant because you had to excavate out to pour the concrete to create the dock.
Yeah. It doesn't tell you that simply digging a hole in the ground is plant.
No. So when we come to see what Mr. Justice McGarry does with the swimming pools, he again recognises that in that case you have to dig the hole to line it, put the concrete in to line it to create the swimming pool. But simply digging a hole without more, this authority does not say is plant, but nor do I. So His Lordship, Lord Reid, recognises that the dock has to be looked at as a whole, the operations have to be looked at as a whole, the dock has an apparatus function, and that is sufficient. His Lordship does not suggest a test of predominance or greater significance or indeed more appropriate. Lord Hodson, at 250 in the bundle, he dissents. So he also cites from Yarmouth and France. To note at 251 letter G, he's recording the commissioners. They also found that the dock was not merely the setting or premises in which ships were repaired and distinguished, but the dock itself plays a role in
I'm sorry, just give me that reference again.
right, page 251 of the bundle, letter G.
Yeah, G, yes, thank you.
His lordship's there referring back to the commissioners. But then at letter I, he says, I should have thought one's first impression would normally be that a dock is essentially a structure, and a structure of the same character in essence as a dam or sea wall. A building or structure is normally to be regarded as something more durable than machinery or plant, hence the differentiation in favour of the less durable. So he starts with a first impression, and at the top of the next page, I do not find the argument based on function convincing. And then he goes on between letters A and B to say that he thinks Margaret was rightly decided. But in doing so, he is rejecting the functional test.
And looking at his homely illustration, do you say that the inspection pit would have been plant? At 744 F to G? G, rather?
I think my answer has to be that it's capable of being plant. I can't say definitively it would be. One would need to know a little more of the facts and circumstances, but it's at least capable of being plant, yes. So Lord Hodson starts with matters of first impression, then looks at other matters by way of analogy, but he's not adopting a functional approach. Lord Guest, over the page at 253, he's part of the majority. He sets out the facts over the page, cites to Yarmouth and France and Hinton and Madden. And then between, just above letter F, the question under Part 10 of the Act is not whether it is a structure or plant, it may be both. The question therefore is whether, notwithstanding that it may be also a structure, the dry dock is plant. He then gets slightly sidetracked by a digression as to whether it has to be an active function or a passive function, whereas it had been accepted in Gerald and has been accepted since, that you don't have to have an active function in order to be plant. But he focuses on function. He recognises that there is a plant-like function, that's between letters G and H. And then notice at letter I, it's said that a dry dock is similar to premises like a factory building in which the trade is carried on. But this comparison is not, in my view, accurate. The factory is, by itself, a building or structure in which trade can be carried on. So reading that in context, he seems to be saying a factory is a building, and it's only a building in which the trade is carried on. And then over the page, between letters B and D, he thinks Margaret was wrong.
So just pausing for a moment at 746I, he says the excavation and concrete, that was what was it, is useless for any trade purpose unless used in conjunction with the rest of the equipment. So there was plant in the sort of pure sense, if you like, and the whole thing functions as one. Is how I read that. You can't divorce them. So you've got the dock gates, the tackles and the other kit that's used for repairing ships, which Lord Donovan, I think, describes as well.
There was various hydraulics and
Yeah.
electronics or electrics by then.
Yeah.
Electronics. Yes, I accept that, but the ratio of his speech, if you like, is that there was a function, an apparatus function, i.e. the dry dock itself, the concrete, was an item with which the business is carried on.
Yeah.
He then goes on to deal with having said Margaret is wrong over the page, he then goes on to deal with the concrete, and he says the concrete also was on the provision of the dry dock, and the dry dock is plant, and therefore you get home. And that's between letters E and F.
Yeah, well, and then he goes on to deal with the excavation.
Yeah.
Necessary, preliminary to the construction of the dry dock.
Yes. Lord Upjohn dissents. He's in the minority. He starts with the concrete work, 748 of the report, letter C. He recognises at letter D that expenditure on a building or structure may qualify as plant. He says, so some deeper investigation of the question is required. And then he describes the operation at the dry dock from E onwards. How does it work? At the foot of that page, paragraph begins, my lord, that is the essence of the operation. And then over the page, at letter B, he starts with Yarmouth and France. He doubts the significance of Yarmouth and France because he says it's not a tax case, it was a case about an unruly horse. So he looks at Lyons, which was a war damage case, where the distinction is drawn between plant and setting, and then correctly he identifies between letters D and E that the divide is between that which is an item in which the business is carried on and an item with which the business is carried on, so we have no difficulty with that. And then between letters G and H, he records the decision of the Court of Session that the dry dock was not merely the setting, but was properly described as apparatus, a word clearly borrowed from Lord Justice Lindley. And he rejects that conclusion. He thinks plant's an ordinary English word, and he thinks it's a misdescription to believe that the dry dock has an apparatus function. And that's between letters H and I.
Yeah.
And then the reason he comes to that conclusion is made clear at the top of the next page, 750, letter B. He thinks that the other side of the argument have placed too much reliance on the functional element. So he thinks that's the wrong approach, and then between letters E and F, he thinks Margaret is right. And then at the foot of that page, 750, and the top of the next page, he says, well, if I'm wrong about the concreting, then he would have agreed that the excavation qualified.
Yeah.
So they split 3-2 on the concrete question, and they split 4-1 on the excavation. And then lastly, Lord Donovan for the majority. He rejects an argument that somehow one should look at the dry dock or parts of it on a piecemeal approach. So between letters D and E, he's looking at the whole of the dry dock. And then he refers to Yarmouth and France.
That's really the key to his reasoning, isn't it? Between D and E. Dry dock
As a whole.
regarded as a whole, with all its appurtenances of operating machinery, power installations, keel blocks, tubular sideshawls, and so on. So he's quite clearly, I would have thought, adopting an entireties approach. He said you must look at the whole thing.
Well, he is doing that, but there is a debate which I will come to in just a moment about the significance of what is logically an anterior question, which is what is it you're testing? But let me accept from your lordship for now that he does say that. I'll come back to the significance of it. But he does recognise at letter E that plant and building or structure are not mutually exclusive.
Yeah.
Correctly. Then he cites to Yarmouth and France and Lyons and Gerald. He then deals with the inspection pit. And then at the foot of the page, and this again is the heart of his decision, the heart of his reasoning, he finds the functional test propounded by Lindley and by Lord Justice Pearson to be as good as any. But over the page, he recognises you don't have to have an active function, it can be a passive function. But his conclusion there is that the dry dock, despite its size, is in the nature of a tool of the taxpayer company's trade. And therefore, in my view, it is plant. So
The dry dock looked on as a unit in the sentence that you've passed over.
Well, I accept that, my lord, yes, he is doing that. But what he's not saying is that its predominant function, or the function of greater significance, nor is he saying it's more appropriate to regard it as apples or oranges. His conclusion is, as is the majority, that the functional test is the right test. And once one identifies that the item that you're looking at has an apparatus function, then it is plant. And the way the contra is put is to say that's not true if it's merely the setting. And then he deals with the excavation. He thinks that qualifies. And then between letters E and F, he thinks Margaret is wrong.
Yeah.
Tab 15, again another Australian case of Wangaratta. It's about a dye plant. It is important, but we'll see why in a later authority. So just to note, useful discussion of the UK cases. Just as a matter of chronology, this was decided in September of 1969, so just after the House of Lords had decided Berkeley Curl. So you get a summary of the authorities up to and including Berkeley Curl in Wangaratta.
Right. Just give me a page reference, if you wouldn't mind. It's all sort of pages 268 and following in the bundle, is it?
It is 268 and following. And you can see that he deals with Berkeley Curl on 270.
Yeah.
And his lordship understands the not merely test, because that's the test that he goes on to apply. So then, turning on to tab 18, beach station caravans. This was the swimming pools in the caravan site, held to be plant. The facts I can summarise very quickly. There were two pools. They were made through excavating, digging a hole, pouring in concrete, lining the concrete, paving the surrounds, and then installing pumps and heaters, etc. And the expenditure that was accepted is at the head of page 296 of the bundle. Some numbered paragraphs. 1 to 4 were accepted to be plant. What was in issue was 5 to 7.
Yeah.
And the case for the Crown was that 5 to 7 are merely part of the setting. And one can see that at letter F on page 296. This is the Crown's argument before the Commissioners, although they repeated it in the High Court. So then his Lordship's judgment begins at 298, Justice McGarry. And then he deals with the authorities at 299 onwards. So he refers to Barclay Curl. And then above letter F on page 299 of the bundle, counsel for the Crown's attack on the decision had at its core two connected points. First, he said the pools were purely passive, whereas the dry dock was active. And then at letter G, second, counsel said it was well established that a building or other structure which did no more than provide a setting where office or other activities could take place was not plant. Thus, the ordinary dividing walls in an office building are not plant, but merely the setting. So that was how the revenue understood the effect of Barclay Curl at that time. And then he refers to Yarmouth and France and Gerald. Then there's a discussion over the page about a radiator, whether it's active or passive. And then his lordship begins the heart of his decision at letter F, subject not free from difficulty, hard to draw a clear line. But then between letters G and H...
Now you say he's wrong to say to some extent the matter must be one of impression, because you say Lord Reed has rejected that.
He has, yes. And when we come on to it, we'll see in due course, but Lord Lowry in the Court of Appeal in Northern Ireland recognises...
That's the Schofield case.
Schofield, that the meaning of plant is a question of law. Once you've decided the proper meaning of the term plant, then it is often difficult to apply. And there may well be cases that an appellate court thinks, well, I might have decided the other way, but that's not for us to interfere as long as the fact-finding tribunal is properly directed itself. So between letters G and H, he considers the two pools as a unit with all the attendant apparatus. Secondly, pools should be considered not on their own, but in relation to the business that's carried on. Well, that's right. Third, he says they're not merely passive in the relevant sense. There's a debate about a springboard. And then over the page at 301, letter B, the purpose of the pool is to provide and retain a suitable body of water which is circulated, cleansed and heated, and will provide a medium in which the visitors to the Caravan Park can safely disport themselves, affording them a pleasurable and safe buoyancy. He recognises that they contain the water, but that's not itself a sufficient reason to conclude that it's not plant. But then his decision, very pithily put between letters D and E, if I may use a relatively modern slang expression, I think this is 1975, pools are not merely where it's at, they are part of the apparatus used by the company for carrying on its business as caravan park operators. The pools are part of the means whereby the trade is carried on, and not merely the place at which it is carried on. And then just 3 lines on, in his reply, counsel for the Crown stressed the question was whether the swimming pool as a whole performed some function. He contended the pool was a mere container with heated and treated water in which people swim, and the pool did nothing. And his lordship rejects that, saying that it merely contained the water isn't sufficient to alter the conclusion. So then, tab 19, Schofield, Court of Appeal in Northern Ireland, Lord Lowry, then Lord Chief Justice. These were the grain silos on the harbour in Belfast, built of concrete, very large monolithic structures, which in simple terms took grain from vessels that docked and then delivered grain to customers who would take the grain away, either bagged or unbagged by truck. And part of that exercise involved holding the grain for a period and then storing it at a level that would allow it to be delivered by gravity into waiting trucks. The question was were the silos plant? Just to note, page 303 of the bundle, page 13 of the report, in case this becomes material in a little while, the company concerned, R&H Hall Limited, stored its own grain that it had bought, and it also stored grain belonging to other people. So one sees between letters G and H, the storage of the grain had two elements. Big customers buy CIF, and the grain becomes their property when invoiced, which would normally be when it is in the ship's hold before reaching Belfast. So Hall was storing grain that had already been sold to somebody else. And then the second is small customers buy the grain ex silo at a price which includes the cost of getting it from the silo into lorries. So some of the grain they were storing was their own grain that they would sell at the point of delivery. And then the next pages, quite a few pages, describe the silos, and they were slightly different. There was the old silo and the west silo, but they were large concrete structures of the sort that I've outlined. So turning to the speech or judgment of Lord Lowry, it begins 309 of the bundle, page 19 of the report.
Can we just pause at paragraph 16 of the case stated on page 309?
Yep.
This is the Commissioner's conclusion. The company was not carrying on the trade of storage, and the silos were not grain stores forming part of the setting. Storage played only a trifling part.
Yes. So there are two. If one wants to divide it, although Lord Lowry is going to say, for reasons like one, it's not relevant. They were storing grain, but they were a grain import business, if you like.
Yeah.
They were buying and selling grain, and necessarily they had to store the grain, whether it was their grain or somebody else's grain, for the period between it arriving on the ship and going out to a customer. I accept that. But the commissioners had found that the function of the silos in relation to that trade was that they served an essential part of the overall trade activity. Their own separate function was to hold grain in a position from which it could be conveniently discharged in varying quantities. So they had found that there was an apparatus function. I don't know why this was done, but there was no High Court hearing. The matter went straight to the Court of Appeal in Northern Ireland. And the question of law was, were the commissioners right to say the silos were plant? Mr. Nolan, you see, appeared for the respondents. So Lord Justice Lowry's judgment begins at 309 of the bundle. He recognises at the foot of 310 that buildings or structures can at the same time be machinery or plant, not mutually exclusive. 311, he harks back to Edwards and Bairstow, making the point in his numbered 1 paragraph that the meaning of plant is a question of law. But once one has understood that meaning correctly, then there will be cases that could go either way. Turning to matters of principle, we pick it up page 22 of the report, 312 of the bundle, letter D. He starts with Berkeley Curl. And between letters F and G, he says this: their decision also shows that they drew the distinction recognised in Berkeley Curl, so it's the commissioners, between a structure which is merely the setting in which a trade is carried on and a structure which constitutes the apparatus with which the trade is carried on, and applied the functional test adopted in that case. So that's what his lordship understands they had done by reference to Berkeley Curl. And at the foot of that page, letter H, one can see how essential are the silos in contrast with mere warehouses. again, the language of merely. And he identifies over the page 23, letters A through to C, the function of the silos. And then Mr. Murray, for the appellant, challenged the findings of the commissioners. His first challenge between letters D and E is the commissioners have based their conclusion on their perception they served an essential part of the overall trade activity, whereas that was not by itself a reason for saying that silos were plant. And his lordship rejects that as a misreading of the decision of the commissioners. But then the second ground of attack was that they had misapplied or misunderstood Barclay Curl. And then from the foot of 23 onwards, his lordship identifies the submissions made by Mr. Murray, so starting with Hinton and Madden, over the page, Lyons, letter D, Barclay Curl. His lordship says at letter E that he thinks the silos clearly had an apparatus function. I have no difficulty in comparing the silo with a series of mechanically operated hoppers. And then at letter G, he says it's convenient to look more closely at Barclay Curl. So he refers to what Lord President, Lord Clyde, had said in the Court of Session. Over the page, he cites from Lord Reed and Lord Guest, passages that we've seen. Over the page, Lord Donovan. And then at letter E, page 26, he says, rightly, the minority view in the House of Lords is naturally worthy of respect and careful study. He records that Lord Hodgson and Lord Upjohn, as he saw it, regarded function as a useful and relevant test, but not decisive. And then he refers to Margaret. It doesn't help the appellant, not least because the majority thought it was wrongly decided. And he thinks it ignores, that argument ignores the fact that the water tower, unlike a factory, performed a function. And then there's reference to a decision of Mr. Justice Templeman in a case called St. John's School about some chemistry lab, which I'm not sure we need note particularly. And then over the page 27 of the report, beach station caravans. And then between letters F and G, he refers to Wangaratta. And at the foot of the page, he refers to Broken Hill. So what you see here is Lord Justice Lowry referring to the Australian cases as having something useful and helpful to say. I don't want to read those passages out, but can I invite the court at some stage to pay close attention to the references to Wangaratta at page 317, letter F, down to the end of the citation from Broken Hill and Wangaratta at the head of 319, letter B. But what those passages make clear is that in Australia, at that time, it was understood that the dividing line was once you found an apparatus function, that is sufficient, because that which is excluded is only where the item merely has a setting function. And then he draws those threads together between letters C and D on page 29 of the report to refer back to the judgment of Mr. Justice Kitto in Broken Hill. The external walls here are not merely in the nature of a general setting in which a part of the operation is carried on, nor do they merely provide shelter for persons as they work and for their equipment. So his judgment is, as the authorities at that stage established, was that the relevant test is it merely the setting? Answer, no in that case. And one can see that that is how he does decide the case. Page 30 of the report, between letters B and D, gives his opinion. And at letter C, he says, to say that they constitute the mere setting within which the trade is carried on appears to be less appropriate than to regard them as a part of the apparatus with which it is carried on. Now, Lord Justice Curran concurs. Lord Justice Jones arrives at the same conclusion and does so for the same reason.
Is that the reference to appropriate you just read out? Is that the first time that word appears? And is it significant in tracing where we get to in the end in this case?
So far as I can see, well, it is the first reference, but it's not a significant.
It's used in a slightly different way from how it's
exactly
subsequently.
When we come to see how it's used later, it's not harking back to this.
No. Okay.
It's a different use of the term. So that's the Court of Appeal in Northern Ireland. And then behind tab 20, case of Benson, this court in 1979, a case about a floating restaurant, which I think is still there on the Thames. It's by Temple Tube somewhere, Hispaniola.
Oh, yes.
It might now be a floating bar, but I believe it's still there. And the debate was the ship itself plumbed because it was a floating bar or a floating restaurant, or is it merely the setting in which the restaurant business was carried on? Held, well, the General Commissioners saw it as plumbed. High Court said, no, that's not right, and the Court of Appeal agreed it's not plumbed. But how they got there, Lord Justice Buckley begins at page 326 of the bundle. He describes the asset. You get that between letters A and D on the page. And then at 328 of the bundle, 339 of the report, he starts the long march for the authorities, beginning with Yarmouth, France. So he mentions Lyons, Hinton and Madden, Gerald. Over the page, between B and C, Barclay Curl. Over the page again, Cook and Beach Station. Same page, St John's School, which was the laboratory. And then just to note, page 331 of the bundle, 342 of the report, this is citing from what Mr. Justice Templeman had to say in the school laboratory case. In the present case, neither the laboratory nor the gymnasium has any function to perform other than to shelter the persons who are being educated. So he's saying there is no other function. That's why they lost in that case. It was just the building. And then he cites to Schofield, Dixon and Fitch's Garage, not a case in our bundle, but it was a canopy over a petrol station. But just to note what Mr. Justice Brightman, as he then was, had to say between letters E and F, the proper test is whether the canopy had a functional purpose. I ask myself, does the canopy help to supply petrol, or is it merely part of the setting where petrol is supplied? He concludes that its only purpose was to shelter customers from the rain. So again, there's understanding there that the relevant test is merely or only. But then
It's not necessarily an easy test to grasp. If you think about the swimming pools, beach station caravans, their function within the business seems to have been to provide an amenity for those who are visiting the caravan park. In other words, to bring in more business. You might say that the canopy protecting people from the weather enables you to sell more petrol, and of course it was argued in the Benson case that having a floating restaurant is in effect a novelty which attracts more people to come and eat there. Now, quite how you...
we see the zenith of that line of thinking in Scottish and Newcastle,
Yeah.
where the argument was that attractively furnishing the walls of a restaurant created ambience, which was a tool of the trade rather than mere setting. And that argument is in part, well, that argument is accepted, but only for some of the items. So it was recognised in the House of Lords in Scottish and Newcastle that items of that sort can be plant. Not that the reverse would be true if they'd lost on everything, but they didn't, they won on some things. So I do accept that, but what Lord Justice Buckley is drawing from the authorities, we say correctly, is that yes, it's a functional test. If there's no plant function, you don't get home. Once you've got a plant function, then you're not merely the setting. And up to this point, nobody has said, and indeed if we go all the way to the end, nobody does say, it's a question of predominant function, or the more significant function, or the greater function. That never appears. Now, there is reference, as I'll show you, to more appropriate, but we need to see what that was about. So Lord Justice Buckley is citing what we say is the orthodoxy. And he rejects the argument here about the floating restaurant because there was no other function. But it's also important here to see what Lord Justice Templeman had to say. Turning on to 335 of the bundle. And at letter H, he says, the authorities disclose a distinction between premises in which a business is carried on and the plant with which a business is carried on. There are borderline cases in which a structure forming part of a business premises has been held to be plant because it does not merely consist of premises providing accommodation. So his lordship understood the test to be merely or only. So he goes on to say at letter J, an item might only provide accommodation or only perform the function. And then over the page, again, he does the walk through the authorities, starting with Yarmouth and France. But to note between letters E and F that Lord Justice Templeman in this court understands Barclay Curl to be authority for the proposition that the dry dock was held to be plant. The dry dock was not merely part of the premises where ships were inspected. That language is also used at G. The swimming pool was not merely part of the premises. Over the page, Schofield, his lordship understands above letter D, that again was a case in which the structure performed a function other than that of merely providing accommodation.
Is he introducing the word merely?
Merely was in Barclay.
It is mentioned.
It is. It's in Lord Reed.
Lord Reed, right.
But then, next passage is of real significance. Between letters D and E, page 337 of the bundle, it plainly appears, therefore, that if and only if land premises or structures, in addition to their primary purpose function, perform the function of plant, in that they are the means by which a trading operation is carried out, then for the purposes of income tax and corporation tax, the land premises or structures are treated as plant. Now, that is significant for two reasons. He's recognising that it is sufficient if you have an apparatus function, and he says that that's true even if the primary function is something else. And if one wants one sentence that encapsulates what's wrong with the first tier here, and I'm going to say the upper tribunal, it's that. But then reading on, it's quite true, as junior counsel for the taxpayer company in the present case forcefully submitted, that the authorities do not illustrate the converse proposition, namely that if a chattel capable of being plant in many circumstances only performs the function of premises by providing accommodation for a business and does not perform any function in carrying on that business, then such a chattel is not plant. But in my judgment, this proposition must hold good. He says the opposite is true, but he expresses the opposite in light of the orthodoxy by saying if it only has a setting or premises function and has no other function, then it's not plant. And then he puts it even more pithily at the top of the last page, 349 of the report. The novelty of dining on the Thames attracts customers to the taxpayers' restaurants, but premises do not become plant merely because they float in the Thames or are suspended in the sky or are to be found on the top of the Matterhorn. For present purposes, I can see no distinction between a restaurant of the Thames and a fish and chip shop in Bethnal Green. Premises only become plant if they perform the function of plant. Tab 22, I don't think we need to look at it because it doesn't take the matter of principle any further, but Scottish and Newcastle was the case about the items that were said to add to the ambience. And creating an ambience was said to be part of the plant with which you carried on the business, and some of those items were accepted. If you got as far as this, there was a debate about some flying seagulls that were on the wall of a hotel in Liverpool.
The Atlantic Hotel.
The Atlantic Hotel, and the higher courts rather doubt that was the right conclusion, but they weren't prepared to interfere. So just continuing with the orthodoxy, I want to come back to Wimpy, so I'm not ducking it. Second volume of authorities. Carr and Sayer, tab 26.
These are the dog kennels case.
These are dog kennels. So this is Sir Donald Nichols when he was Vice Chancellor. And there were two types of kennels. There were movable kennels, which were accepted to be plant. So they did the same job of holding dogs, containing dogs, providing a place for dogs to be quarantined, but they were plant, and the debate in the courts was about the permanent kennels. And the General Commissioners said, well, movable qualifies, permanent does not, and the High Court said that was right, the permanent kennels are not plant. Lordship's judgment begins at the foot of bundle page 424. Mr. Henderson appeared for the Crown. The taxpayers didn't appear. Mr. Henderson had to put both sides of the argument. Over the page, heading plant at letter G. Right at the foot of the page, there's no statutory definition of plant.
So the commissioners are objecting to the movable kennels being allowed as plant.
Well, both
That's
sides.
why they appeal?
Both sides appealed, yes.
Both sides.
Yeah.
Right. Right.
And that becomes clear. Page 425 of the bundle, letter C. Both parties were dissatisfied with the decision, but the Crown does not now seek to challenge the Commissioner's conclusion regarding the movable kennels.
Right. And what is the difference in function between the movable kennels and the permanent kennels?
It is rather difficult to see what the difference is.
So if one qualified as plant, then on your argument, the other should equally have qualified as plant.
One needs...
Is that right, isn't it?
It's not quite as simple as that, but I accept the force of logic's observation that you would think they're there to quarantine animals. But the Crown accepted that the movable kennels had the relevant function. Now, the Commissioners had decided that. We don't know why the Crown, having appealed, conceded. But we do know that the taxpayer went on to contend, although taxpayers didn't appear, that the permanent kennels should have been plant.
Yeah. And the Revenue was saying no. And the Vice Chancellor said to the Revenue, you're right.
Yes.
So that I can't see how that can be simply looking at the function of the, let's call them items, to use a neutral word, because the items, whether movable or fixed, would appear to perform exactly the same function. except that one lot could be moved and the other lot couldn't.
But I accept that, but his lordship doesn't rule on the movable kennels because the Crown have conceded the point.
And we don't have the argument of Mr. Henderson, as he then was for the Crown's argument, to distinguish between movable because they didn't pursue their appeal.
That doesn't appear to have been part of the debate. Mr. Henderson put the case for the taxpayer as regards the permanent kennels, but his lordship doesn't address the movable kennels. So we don't know what his lordship might have had to say about the rightness of the concession about the movable kennels. But it's the principles that his lordship sets out. Page 402 of the report, 426 of the bundle, letter B, he sets out 5 numbered principles. So he begins with the notion that plant carries with it the connotation of equipment or apparatus, fixed or unfixed. It does not convey a meaning wide enough to include buildings in general. And then he goes on to say, well, premises would normally be understood as not being plant. I'm not sure that as a matter of principle takes one very far. He's just saying what might normally be the case. And then secondly, above letter D, the expression machinery or plant is apt to include equipment of any size. So size, fixed or movable, doesn't matter. And then reading on, the equipment does not cease to be plant because it is so substantial when fixed it attracts the label of a structure. That's true. Third, equipment does not cease to be plant merely because it also discharges an additional function, such as providing the place in which the business is carried on. He expresses that third principle again in terms of merely. And then fourth, and conversely, buildings which I've already noted would not normally be regarded as plant do not cease to be buildings and become plant simply because they are purpose-built. And that must be right, a purpose-built building is still a building. And then fifth, one of the functions of a building is to provide shelter and security for people using it and for goods inside it. That is a normal function of a building. Again, I don't disagree with that, but it doesn't help greatly here as a matter of principle with the question we're facing. But then he says at the foot of that page, when these principles are applied in the present case, they seem to me to lead inevitably to the conclusion that the permanent quarantine kennels are not plant. And he arrives at that conclusion on the primary facts found by the commissioners. The kennels are purpose-built permanent structures. They are the premises at which and in which the business is conducted. True, they are specifically designed for quarantine purposes by having the structure made of particular materials. The roof is made of steel and the walls are impermeable. These features are building design features and no more. He's saying there is no other function of these permanent kennels. And on the primary facts as found, that leads inevitably to the conclusion that they were not.
Can we look at page 403 between G and J, where Sir Donald says, I recognise the consequences to draw a stark contrast between temporary movable and permanent immovable, former of plant, the latter are not. I do not find this odd. Both perform a similar function, but the latter, unlike the former, have been constructed in such a way they are on the buildings or premises side of the boundary line. So that does not look like simply a function test, does it?
He is identifying there that his lordship's understanding they have the same function. He is recognising that a distinction is drawn between the permanent and the movable. He doesn't explain what it is that he sees as the difference between the two of them. He just says on the primary facts found, the asset he was addressing was the permanent kennels, and he thinks they're plant because they have no other function.
But doesn't this undermine the idea that function is the only answer, the only test?
If it might be that's not what he's saying, but if that is what he's saying, then that's not consistent with Berkeley Curl, because that was what drew the distinction between the majority and the minority. But Carr and Sayer is difficult, because whilst his lordship sets out some helpful general principles with which I do not disagree, indeed I rely on them in large part, he doesn't explain crisply what it is that puts the permanent kennels on one side of the line, where he is here accepting, though not explaining, why the movable temporary kennels were on the other side.
Do you say it was wrongly decided?
No, nor do I need to say that. But what I do say is there's nothing in his lordship's 5 principles on page 402 of the report that is inconsistent with the analysis I've offered to the court on the basis of Berkeley Curl, Schofield and Benson and all the other authorities. Now there are a couple of other cases, but I want to come to them in a moment when I address the upper tribunal's understanding. Just for your note more than anything, behind tab 36, there's a very recent decision of the upper tribunal in a case called Urenco, where I appeared with Mr. Ripley. It's about uranium tails reprocessing facilities, so a very, very different asset to what we're concerned with here. But in part, the debate there was about the common law meaning of plant. And the upper tribunal set out their analysis at 680 of the bundle, page 12 of the report, the heading, the meaning of plant and relevant case law. And they do the exercise which we in effect have done, adding in a couple more cases. And then they draw principles at paragraph 62, page 686 of the bundle. And they have 8 numbered principles.
And they seem to have followed this case. Do they not?
No.
No.
No. They set out their principles in what I would regard as the orthodoxy.
Right. So because they quoted the summary principle in this case at 61.
They do. But the principles they set out in paragraph 62.
You say they're different.
Well, I say that they are the orthodoxy. So one looks in particular at principles 2, 5, and 6. But they recognise in paragraph 63 that may be different to the approach of the upper tribunal in this case. And the same is true when they come back to this in paragraphs 76 and 77. They express in 76 what I say is the orthodoxy, and in 77 they recognise that this present appeal might be different.
Are the principles in paragraph 62 your principles, which they accept, Mr. Pupil?
They do, yes.
Yes.
They heard from me what your lordship, my lady, heard from me this morning, and they accepted it. Now, that's a decision of the upper tribunal. In a sense, they're either right or wrong. But if one wants a recent exercise, this is just a couple of weeks old, it's a very recent exercise in drawing principles from the authorities that we've looked at.
Yeah. And you say that they talk about merely setting, merely. They use the word merely 2 or 3 times.
Yeah. Drawn from the authorities that I've shown you.
Yeah.
So from that walk through the authorities, we say that the line long understood in the case law is that we are looking for an item with which, not in which, the business is carried on. If you have an item that has both functions, it is to be regarded as plant. it is necessary and sufficient that the item has an apparatus function, and the item is only not plant at common law if it only or merely has a setting or premises function. Now, the court is alive to this, but the decisions below said, no, that's not right. First tier thought the test was one of predominant function, for which there is no warrant in the authorities. Indeed, it's flatly contradicted by that sentence I showed you from Lord Justice Templeman in this court. The upper tribunal recognised, in effect, that the first tier got the test wrong. But the upper tribunal say, well, the real test is it more appropriate to regard it as apples or oranges, and that in substance is the same. The upper tribunal were wrong about all of that. More appropriate is not the right test. They are not the same test as the first tier applied. The upper tribunal should have identified that as an error of law. So where does, pause there. There is an exercise to be done in walking through the decision of the first tier. I come prepared to do it. I'm not sure just how useful it is, because the headline of my complaint is that the judge below has found a predominant or a more significant test that's not there in the authorities, and that's the test that she applied. I have chapter and verse on that. But in one sense, I'm appealing against the decision of the upper tribunal.
Yes.
So my primary target has to be the upper tribunal rather than the first tier. But can I make clear to the court that if it becomes necessary, I can go back and walk through the first tier to point out where all these interlinking errors arise. I only not do it now in the interest of time, but because my primary target must be the upper tier.
Exactly.
See, the court has my headline answer to the errors made by the first tier. Where does the upper tribunal go wrong? Now, we attempted in our skeleton argument to identify propositions, if you like, or waypoints on the argument. So if you have our skeleton argument to hand, paragraph 29.
Paragraph 49.
29.
29. Yes.
So I can't read those out. Propositions 1, 2, and 4 relate to what is the right test question. Proposition 3 is the correct recognition by the upper tribunal that test applied by the first tier is not in the authorities. And then proposition 5 is, well, in substance, they're the same. And then 6 and 7 are more minor complaints that the first tier misunderstood our case and have misunderstood or misread Schofield. I'll come back to 6 and 7, but the heart of my attack on the upper tribunal relates to what we identified there as paragraphs 1, 2, and 4. So where does this notion of more appropriate come from? So the court has my submissions as to the right test. I made those submissions to the upper tribunal, and in their discussion of the authorities, the upper tribunal do acknowledge that that reading of the authorities was at least plausible, if not right. I say that for this reason, because I need to point where they do go wrong. But in the upper tribunal, paragraph 20, it's page 82 of the 4 bundle tab 6, they have a heading Case Law on Plant, and they refer to Yarmouth and France, Gerald. Just to note, 5 lines up from the end of the paragraph 21, Lord Justice Ormerod, something more than a mere setting for the carrying out of the trade, in other words, as coming within the definition of plant, so more than mere. Paragraph 24.
Lord Justice Donovan puts it slightly differently. It's
does.
more a part of the setting than part of the apparatus.
He does. Yes. Gerald, there is not a single voice. Except that.
And Lord Justice Pearson says you could take either view.
Yes. He does. But in citing from Barclay Curl, paragraph 24, they summarise their understanding of Lord Reed. It was wrong to regard the concrete part of the dock as mere setting. Lord Guest, they understood paragraph 25 as looking to see whether the dock may also be a structure. Notwithstanding the dock may also be a structure was plant. Paragraph 30, they correctly record their understanding of beach station caravans, 3 lines up from the end of 30, not merely the place, harking back to Lord Justice Pearson. Paragraph 32, their understanding of Schofield, they were not in the nature of a general setting or mere shelter. Benson, paragraph 35, Lord Justice Templeman, borderline cases in which the structure forming part of business premises has been held to be plant because it does not merely consist of premises. Same references at the top of the next page. And so on. So they were alive to my submissions as to what was the orthodoxy. They appear to accept those references and those understandings of those authorities, but they then say ultimately, no, they think the test is different. So ultimately, their approach is to say the relevant test is whether it is more appropriate to regard an item as plant rather than setting. Now, there's a point of principle here. They're saying that's the right test as a matter of law. Where you have an item that might be said to have both functions, as a matter of law, one should ask oneself, is it more appropriate to regard it as A or B? And there is a huge practical difficulty with such a test as a matter of principle as to how one might go about applying that test in a given case. What factors are to be addressed? What is the parameter for the regard? And how does one go about drawing lines of principle between items that should qualify and items that should not? This notion of a more appropriate test, more appropriate to regard it as A or B, I'm afraid is a recipe for future litigation. It does not draw a principled divide between the two, when all of the authorities we have seen are an attempt to draw a principled divide looking at the common law judge-made meaning of plant. Where does it come from? Before testing whether an item is plant, there is often a logically prior question as to what item you are looking at. Best example I can think of is an oil rig. You could see the entire rig as a single item. And you'd have to ask, is that item plant? Or you could say, well, actually, it's a separate item, it's a series of separate items made up of the platform, the drilling unit, the processing unit, the accommodation unit, the control unit. And you'd ask each of those units, are they plant? take that to its logical conclusion, you could say, well, we've got to look at each component down to every bolt and every rivet and ask, is that plant? Now that's fanciful, it just doesn't work. But logically, you could go down that line by subdividing until you arrive at a point where you ask, of a given item, is it plant? Now, what the case law says is you have to decide, as a first step, are you going to adopt what's called the entirety approach, or are you going to adopt what's called the piecemeal approach? It being fairly obvious that one requires you to look at the whole item, so maybe the whole rig, and the piecemeal approach would require you to look at different elements of the rig. So you might form the conclusion that the processing plant on a rig is plant, but the accommodation unit is not, for example. So that's the logically prior question. And the case law says, well, that's ultimately a question of fact, or fact and degree, for the fact-finding tribunal. The fact-finding tribunal has to decide for itself what is the natural or the better unit to be tested. So it would be here for the first tier to decide, we're not going to look at the whole rig, we'll look at different items on the rig and then test those. And the phrase more appropriate has been used in the authorities in the context of a debate about whether to look at the entirety of an item or at separate units. And we can see that in the Wimpy case, the restaurant case, and we should start with the decision of this court, which is in the second volume of authorities, at tab 24, 1988, Lord Justices Fox, Lloyd and Glidewell. And this was an argument about...
Sorry, which tab was it?
tab 24.
24. Thank you.
And one gets the nature of the debate, one turns to page 391 of the bundle.
This was essentially a fit-out of the Wimpy bars.
It was Wimpy and Pizzaland. And the items you can see that were still in dispute in the Court of Appeal, the head of that page, so tiling, suspended ceilings, mezzanine floors, etc., etc. And on that page 391, His Lordship is explaining the history of the litigation. So Mr. Justice Hoffman had upheld the commissioners on all items except number 10. There's an appeal from the taxpayers, no cross appeal by the Crown, reference to Yarmouth and France. And then he summarises the judge's test below. And there's the citation between letters G and J to what the judge had said below about the business use test and the premises test. And one of the debates below and in this court was whether the items, so Artex on the walls, for example, or floor and wall tiles, had they become part of the premises? What the judge, this is Lord Justice Fox, the judge's conclusion and review of the authorities, the question was whether it would be more appropriate to describe the item as having become part of the premises rather than as having retained a separate identity. So that's the first instance in this court we can see of this notion of more appropriate, but it's used in the debate about whether one should be looking at the item itself alone or whether it had become part of the premises.
And you say that that only matters, do you, if the premises are mere setting?
Yes.
If the premises are more than mere setting, then it doesn't matter whether these items are part of the premises or not are part of the premises, they will be plant.
Yes. But in the Wimpy case, because they were dealing with cafes and restaurants, you were looking at what was undoubtedly a building that was undoubtedly the premises in which the business is carried on. And one of the stages in the analysis of the claim for plant and machinery was, if you're thinking about the artex or the tiles, do you test them alone, or have they become part of the premises? And his lordship says, well, you can answer that question. It's the entirety type question by asking, is it more appropriate to see it as a freestanding item or as part of the premises? But that is to answer a different question to the question we're concerned with, which is whether this is plant or not. Now, just to complete this exercise, the lordship makes the same point, page 280 of the report 396 of the bundle. Between letters E and F, I would agree with Mr. Justice Hoffman. The question is whether it would be more appropriate to describe the item as part of the premises rather than as having retained a separate identity.
Sorry, where are you?
E.
280 E to F, page 396.
280.
396 of the bundle.
Yeah, E to F.
E to F, I would agree with Mr. Justice Hoffman.
Just pausing for a moment at 392 of the bundle, 276 of the report. Letter A, Lord Justice Fox is summarising taxpayers' argument. Question is whether the item in dispute performs or is part of an item which performs the sole function of housing a business, or whether it performs some other distinct business purpose. If it does, it is plant. That sounds like your submission.
It is. It was Mr. Aronson advancing what he thought then, and I think now is the orthodoxy.
But that's not what the court of appeal itself is.
Well, no, they in effect sidestep that by saying there's still a logically anterior question you have to address, which is what is it you're looking at? And they come to the conclusion that the items, when they start to walk through the various items, they deal with them in turn, but what they're deciding then is whether the decision of the commissioners was right, or in some instances whether the decision of the judge below, having varied the decision of the commissioners, was right. But ultimately all Wimpy and Warland is an example of this court having to do that item-by-item exercise against the backdrop of a logically prior decision as to whether an item was or was not part of the premises.
This case is very fact-specific, it seems to me, in dealing with a building. We're quite a long way from a building in this case, aren't we?
Yes. You can see, in light of Scottish and Newcastle, that said if you run a restaurant business, there are some things that create ambience that you might say are an embellishment and therefore a tool of the trade. This case is an extension of that to say, well, there are some things that we put in that are part and parcel of creating the right atmosphere to sell more food and drink to our customers. And it might be thought that they were pushing the envelope by claiming things like the artex on the walls or the wall tiles.
I'm still slightly troubled in the back of my mind about the difference between the kennels.
Between
the kennels. And of course you have restaurants in buildings and restaurants, cafes in temporary structures. And you might get a different answer to the question, is it plant, depending on whether it was in a building or a temporary structure.
Well, that was really Benson. The argument was, well, because we're a floating restaurant and the floating bit is the attraction, that would turn what might otherwise be a chip shop in Bethnal Green, brackets, not plant, into something that was plant. Court of Appeal say no, it's just the site, it is just the site or the setting of your business, it's nothing else. Now, ultimately, Wimpin Warland is a very fact-specific decision of this court about the claims made in that case. But the significance from my point of view is that what is picked up by the upper tribunal here is this sense that somehow the test as between plant and not plant is to require you to ask, is it more appropriate to see it as A or B? And the reference to more appropriate in Lord Justice Fox's decision is addressing a different question. And we can see that from Lord Justice Lloyd's decision, judgment, page 289 of the report, 405 of the bundle. Letter F, counsel for the Crown argues that before you ever get to apply any test, whether the functional test or any other test, you must first determine the subject matter of the inquiry. What is the entity to which the test is to be applied? That's right. And then at letter 8, that leaves only the question, which perhaps is the most fundamental question of all, how do you decide whether you're dealing with one entity or two?
Again, sorry for interrupting again, but you missed out what he said at the bottom, second half of that paragraph, G, about where there's only one entity. You apply that test to the entity as a whole.
Yes. Yes. I don't shy away from that. I wasn't skipping it for forensic reasons. It is undoubtedly what he says. But then he picks up what the judge had said below, echoing a point made by Lord Lowry, Schofield, and then you see the more appropriate language, but it's in the context of answering a different question. It is also the case that this more appropriate phrase appears in Bradley and London Electricity, behind tab 28. And this is the case about an electricity substation that is buried under Leicester Square. There's a little cabin in one corner of Leicester Square, which is the cabin that Orson Welles might have disappeared into at The Third Man, that has stairs that go down. And underneath Leicester Square, there is an enormous electricity substation. The debate in Bradley was not about the electrical kit inside the structure, which was accepted to be plant, but about the structure itself. And in simplistic terms, it was a concrete cube buried under the square that was necessarily in place to hold the kit. And London Electricity claimed allowances on the concrete cube. So the Special Commissioners said, yes, it was plant, and Mr. Justice Blackburn in the High Court said, no, that's not right. But can we note paragraph 17 of the Special Commissioner's case stated, which is page 449 of the bundle, 1067 of the report. not sure I need to read out the whole of that long paragraph, but in that paragraph he's dealing with the entirety question. So what is the item to be tested? And then the significance of that appears if we look at the judge's judgment, which begins page 456 of the bundle. And in particular, page 464 of the bundle, 1082 of the report, at letter A. It is important in this connection to appreciate that what the Special Commissioner was concerned with was the structure as a single entity rather than particular parts of it. And then His Lordship refers to their conclusion of that. And then between letters F and, or letter G, he says, in concluding that it was more appropriate to describe the structure as apparatus for carrying on the business and as the premises in which the business is conducted, the Special Commissioner clearly had in mind the premises test as it has been described, articulated by Mr. Justice Hoffman in the Whipple case.
I'm sorry, I'm behind you, Mr. Peacock. Where are you?
Well, I'm sorry, I picked His Lordship's judgment up at page 1082.
Yes.
Letter A begins the debate about is it one entity or two?
Yeah. He just said that the essential question, starting at the bottom of the previous page, is whether the structure, as distinct from the equipment, can reasonably be called apparatus with which the business is carried on, as
Yes.
opposed to the premises in which it's carried on.
Yes. And he's then making the point that what the Special Commissioner had tested was a single entity.
Yeah.
And he then cites from Wimpy and from what the Special Commissioner had to say. But then picking it up at the foot of that page, he harks back to what Lord Justice Fox had said in Wimpy. What is the function of the item in question? In this case, the structure as a whole. What does that structure function as? It is the absence of any plant-like function performed by the structure as a whole that distinguishes this case from cases referred to by Lord Justice Blithewell in the Wimpy case as the second category. His Lordship there is respecting what I say is the orthodoxy once one has decided the item in question to be tested. And that is the ratio of his decision can also be seen at page 466 of the bundle 1084. Between letters F and G, in my judgment, the Special Commissioner failed to ask himself what plant-like function the structure as an entity performed in London Electricity's trading activity. He had the true and only reasonable conclusion to have come to was that premises, no plant-like function was identified for the structure as a whole. So that's an application of the orthodoxy that he had understood Lord Justice Fox in Wimpy to be dealing with the logically anterior question, which is it one entity or two? And then the last case that I think I need to look at on this submission, because it's heavily relied upon by both the first tier and by the upper tribunal, is the next tab 29.
The car wash case.
The car wash case. So it's important to note that the primary argument of the taxpayer in Andorf was that the whole site, so it's not necessarily university view, but think of a corner site. the argument was that the whole site, including the driving on bits and the parking bits and the driving off bits, including the wash hall and including a couple of ancillary buildings, the whole thing was a single item of plant.
Yeah.
The argument being it's a single entirety, and then you test that. The fallback case of Mr. Whiteman for the taxpayer was to say, well, if that's not right, we'll just look at the wash hall. And the special commissioners had said that the whole site is plant. They had this rather graphic metaphor of it being the whole thing being a machine that would take a car in, clean it, and then spit the car out at the other end. And the courts say, well, no, that's all rather fanciful. The High Court said, no, that's not right. Court of Appeal agreed. And the Court of Appeal rejects the taxpayer's primary case about the whole site, but they also reject the fallback case about the wash hall. So, page 470 of the bundle, 1169 of the report, Lord Justice Peter Gibson, just above letter D, the primary contention of the taxpayer is that each site constitutes a single unit of plant. Over the page 471, letter C, two findings made by the Commissioner particularly relied upon by Anduff. The first is this: the IMO system encompasses not only the machinery inside the wash hall, which carries out the actual washing operation, but the whole concept and design of each car wash site, etc. They clean up to 90 cars per hour. So the argument was, on the basis of that finding, is that the whole site functions as apparatus. And then over the page 472, between letters E and F, the judge below had said the commissioners had failed to apply or had misapplied the appropriate test, so they got the test wrong. And then letter G, the main question of this court is whether on the facts found, the conclusion that each Andoff site is a single unit of plant is one which no person acting judicially and properly instructed as the relevant law could have come to. And then at letter J, I should also make it clear that in my opinion the same is also true of the question within the main question, viz. Whether it is appropriate to ask is it plant in relation to the entire site or to the wash hall alone or to each component part. So that is saying that there's a logically prior question. You have to decide whether you're going to ask the plant question of the whole thing or of one or more units. So that's another reference to appropriate, but it's in the context of the logically prior question of entirety or piecemeal. And then over the page 473, letters A and B, taxpayers' primary and fallback cases. And then his lordship walks through the authorities. Referring in passing to Wimpy, Schofield. Recognise at the foot of page 474, Court of Appeal in Wimpy, Lord Justice Fox rejected an argument of the taxpayer based on the observation of Lord Justice Oliver and Cole brothers, and then he cites from what his lordship had to say. And then over the page, Carr and Sayer, and then at 476, letter B, he helpfully identifies the authorities in which what he says are the premises are themselves plant. Now, that's slightly misleading because some of the items that he goes on to address are not premises. They're structures. So what he should have said, to be more accurate, is where premises or setting are themselves plant. Then he lists them: Barclay Curl, Wangaratta, Beach Station, Schofield and Hall. There's an Irish case. Over the page, case in our bundle, I haven't taken you to Waitaki about a cold store. But equally, beginning at letter B on 477, tax cases on plant, whilst of interest as providing examples of the satisfaction of the premises test, do not seem to me to provide factual situations analogous to the present case. And then he refers to Benson. Just between letters C and D, there, so this is Benson, Lord Justice Buckley contrasted a structure by means of which the business activities are in part carried on with a structure which plays no part in the carrying on of those activities, but is merely the place within which they are carried on. And that is, I say, a recognition of the orthodoxy and not a departure from it. Then he goes on to 6 or 7 lines down, the question in each case, as Lord Justice Fox said in Wimpey at 280, does the item function as premises or plant? To answer this may involve deciding whether it is more appropriate to describe the item's apparatus for carrying on the business or as the premises in or upon which the business is conducted. If you go back and look at what Lord Justice Fox had said in that passage, as I showed you in Wimpey, his lordship there is addressing the logically anterior question of entirety.
So you say that Lord Justice Peter Gibson was wrong to pose that question?
Not wrong, but it has to be read in context. He's referring back to the question posed by Lord Justice Fox, which is a question about identifying the item which you're testing.
So if there's been a wrong step, you say it was a wrong step. In this case, nothing to do with the First-tier Tribunal or the upper tribunal here, that this was Peter Gibson using the appropriateness test out of context.
Put like that, yes. If one wants to ask where do I say it went wrong, it's the failure to appreciate that the more appropriate phrase is used in the context of the entirety question. It's not even clear that his lordship, Lord Justice Peter Gibson, gets it wrong here, because it rather depends where the emphasis is put in that sentence. Sentence before, does the item function as premises or plant? Well, that carries with it the requirement to identify what the item is. So
okay, so do you say he's right? Do you criticise the way in which he summarised Lord Justice Fox's question? Does the item function as premises or plant? Is that how, I can't remember, is that how, precisely how Lord Justice Fox put it?
It's not exactly how he puts it, no.
Does the word merely have to be put in somewhere there?
Lord Justice Fox uses that term further on in his judgment, not in that passage. Should the question be phrased, does the item function as plant or merely premises? Yes, but the emphasis here may be on the item or this item. It may be that what his lordship is saying, by harking back to what Lord Justice Fox said in Wimpey, is you have to identify the item. And if he's doing that, then I have no criticism of it.
Does these couple of sentences in Lord Justice Peter Gibson's judgment form part of the ratio of this decision?
Ultimately, no, because he's going to go on to conclude that if you take the taxpayer's primary case, then the whole site, if you look at the whole site, it only functions as premises. And if you look at the wash hall, he comes to the same conclusion. So the reasoning he actually goes on to apply is, I say, the orthodoxy. But what the judge in the first tier picked up, we say by misreading and it's certainly taken up by the upper tribunal, is that somehow you answer the plant question by asking, is it more appropriate? Here it's put more appropriate to describe. The upper tribunal put it as more appropriate to regard. But what Lord Justice Fox is actually doing is addressing a different question.
The example he quotes is the kennels case.
It is, and that's helpful, but only up to a point. But what he goes on to do is to test the taxpayer's primary case that the entire site is a single unit of plant. Now, he's going to go on to say the Special Commissioner's got that wrong.
But as my Lord points out, the reference to Carr and Sayer seems to be inconsistent with the submission that you are advancing, because Lord Justice Peter Gibson says that the quarantine kennels were part of the means by which the trading operation was carried on, yet the premises test was not satisfied. Now, on your argument, those two statements cannot stand together. Once you've decided that the kennels were part of the means, they are plant.
That sentence, to say that they're an essential part of the business doesn't get you home, and we know that from Yarmouth.
We know that, but that's not the way he puts it. He says they were part of the means by which the trading operation was carried out. That, you say, is the test.
Yes, but if you go back and look at what Sir Donald Nichols actually decides in Carr and Sayer, his conclusion is that the items were merely the setting.
So Lord Justice Peter Gibson, with respect to what you say, has miscited or inaccurately summarised.
Yeah, misremembered or misrecalled.
It's wrong, anyway.
It's not what the judge actually decided.
But none of this is relevant to. None of this was part of the ratio.
No.
So this is all a bit.
Because ultimately the ratio was, were the Special Commissioners entitled, as regards either the whole site or the wash hall, to say that they had a plant, an apparatus function? Answer, no.
So your case is that the Upper Tribunal went wrong because of a series of slight misstatements in this particular line of authorities, from Wimpy to Carr to the Kennels case to the car wash case.
Yes.
The car washes.
And we can see that because we can see that in the way that the court goes on actually to decide Andoff. So this is Lord Justice Peter Gibson. Page 478, 1177, he rejects the rather fanciful metaphor of the commissioners at the top of that page, that it was a conveyor belt to take in, clean and spit out cars. And then just above letter C, I do not doubt that the vacuum equipment is machinery or plant. It is impossible to say that the bays where the cars are parked whilst the vacuum cleaning is done have any function other than as premises. And then at letter D, the Commissioner's conclusion on this point is contradicted by their findings of primary fact, from which it is apparent that the site outside the wash hall is not functioning as plant, but is simply premises serving a premises function. So he rejects the case by application of what I say are long-standing principles. And what then of the wash halls? This is the fallback case. He criticises the Commissioner's analysis of the wash hall as being very inadequate. And then his conclusion is that even looking at the wash hall, there is no plant function at all. And that one can see, one reads on letter H and J of 478, and then over to the top of the next page. The ratio of his decision is to apply what I think, my submission, are the orthodox principles. He says whether you look at the taxpayer's primary case or their fallback case, there is no apparatus function, taxpayer loses. And that reference to more appropriate is taken out of context and misunderstood. The Court of Appeal, even in Anduff, were not saying that the relevant test is whether it's more appropriate to regard the asset as one or the other. And your Lordships will have seen that the other two members of the court simply agree. So that is,
Yeah.
he speaks for the court. Last authority, in chronological terms, that just bears on this is the next tab, Shove and Lingfield. This was the all-weather racetrack at Lingfield, where the claim was for the all-weather surface. Was that plant? General Commissioners said yes. High Court and Court of Appeal said no. And it's judgment of Lord Justice Mummery. Mr. Milne appeared for the taxpayer. And if you pick it up at 484 of the bundle, 809 of the report, paragraph 16, he's dealing here with Anduff. And letter H, Peter Gibson, Lord Justice Peter Gibson, with whom Lord Justices Walker and Beldam agreed, held the only reasonable conclusion was that neither an entire site nor an entire washhall could be regarded as a unit of plant. Although they satisfied the business use test, they failed the premises test, as both the entire site and the washhall functioned as premises, not as plant. No plant function. And over the page...
The last line of that paragraph, it's hard to see how land as distinct from the structure can be apparatus. We're dealing with land, aren't we? That's what that is it. The cavity is part of the land.
Well, that's a separate debate, my lord, as to whether...
Well, is it?
Well,
It's surely part of the common law, so-called, of what plant means. I know that alterations to land are specifically mentioned in the statute, but Lord Justice Peter Gibson is not concerned with that at Atwood, and nor was Lord Reed in Berkeley Curl. Now, Lord Reed talked about land in its natural state. Lord Justice Peter Gibson was not quite so restrictive, and in Lingfield, the court goes on to say, well, this is altered land, but nonetheless it's land, and it's not plant.
Well, it's land and not plant, not plant because it is land.
Well, it's land rather than plant.
Well, to give an example, my friend and I, we debated in the Court of Appeal in the SSE case. Imagine a shooting range, and you bank the earth up at the end of your rifle range to capture bullets and to avoid spent bullets escaping the site. In those circumstances, that is something that is capable of being plant. I cannot say it necessarily will be, but it's capable of being plant. It's not land in its natural state.
So what, if you fill up a disused quarry with water and invite people to come fish in it, is that plant?
It's not, I don't think I can say definitively it is plant, but it's not plant. There's no logical or principled exclusion. What you've got to do is apply the authorities. I mean, my Lord's observation is very much the argument that the revenue are running in beach stations. all you've done is dug a hole and put water in it.
Well, except the pool in beach stations, first of all, wasn't just a hole.
It was lined.
It was a lined hole. And secondly, as the judge held, it was part of an integral system and could not be divorced from all the filtration and purification kit.
Mr. Justice McGarry does say that, but he does say that the water itself in the pool provided a function had a function of providing pleasurable buoyancy. So there is a debate to be had when we get to the statute, that would it make all the difference in the world? Once we'd leached and debrined, if we dropped some rather clever hosepipe down that has sprayed a polymer round inside and lined it to make a polymer-lined container, let's assume we did that, it cost us another 5 million. Does that then make it plant? I.e., do we have to spend more money to qualify for the allowances? In a sense, that shouldn't be right. So does it make all the difference in the world that we could have artificially lined these cavities? The answer should be no. We happen to have rock that, once you treated it in a certain way, would make it impermeable and hold the gas.
And all you did was put water in it.
Well, all we did was put water in, wait for chemistry to work its magic, and then we took the water out.
And you say there's no difference because water between that and putting something else in it, because that it's a process which happens.
And in theory, at least, my clients may shudder at this, but you could store other things in that.
Well, that rather detracts from your argument, because if you could store other things, it becomes more premises-like, less functional.
No, not necessarily. No, the point is you have to. By other things, I meant not just what I literally think of as North Sea gas, not just methane. Could have stored different gases down there. But the point is this: that we have undoubtedly, as regards the leaching, altered the land. We've conceded that, there's no debate about that. There's a separate debate about whether debrining alters the land, but that's a statutory question for a little while. But as regards the cavities themselves, this is not simply land in its natural state.
No.
And what led the court to decide against the taxpayer in Shove, well, first we just ought to see how his lordship gets there, because paragraph 20, page 485, Mr. Milne had won before the commissioners. So Mr. Milne took the court through all the recent cases, making the arguments to support the commissioner's decision. It was, he submitted, a decision on a matter of fact and degree that was reasonably open to them, and that, in effect, the appellate court couldn't interfere. And his lordship at 22 rejects that. It's not simply a question of fact and degree. His lordship thinks the General Commissioner's got the test wrong. And why does the court think they got the test wrong? That's because, one can see from paragraphs 23 through to 25, because the court said there was no apparatus function. I still have some threads to draw together on like ground one, common law of plant. I'm told it is 12:59.
Yes, all right. We'll do that at 2 o'clock.
Court rise.